Welcome to This is Supercritical, a podcast where experience, equity, and expertise converge to examine current trends in the cannabis industry. You can find all of our podcasts on your favorite streaming service and at supercritical.agency, your one-stop destination for all things cannabis. Hello, I'm Kerry Jordan.
And I'm Sparky Rose.
We're the co-founders of Supercritical. Joining us on today's episode of This is Supercritical is Kristinia Dahmann, a partner at Ice Miller. Kristina provides regulatory, risk management, and general business advice to cannabis startups and multi-state operators. She has broad litigation experience encompassing traditional business, bankruptcy disputes, employment defense, and energy environmental litigation. We're going to learn so much from her today. Kristina, welcome to This is Supercritical.
Thanks so much. It's great to be here.
So on today's podcast, we want to talk about hemp-derived cannabinoids, the legal and regulatory framework in which they currently operate, and then a little bit about what's going on in the regulated cannabis market. So for starters, would you please describe for us the current federal regulations governing hemp-derived cannabinoids in the U.S.?
I would be pleased to, and it's actually somewhat of a good premised question because it's an easy answer in that there really aren't any current federal regulations concerning hemp-derived cannabinoids. And that is because the Farm Bill legalized and allowed for there to be hemp-derived products in the United States through either state programs or USDA-sponsored programs. However, it has been a struggle to have clarity on the regulatory framework as it relates to these hemp products. Namely, we haven't had a buy-in from the key regulators in the space, namely the FDA, in that they have explicitly stated and have positions that are contrary to what really has been going on in terms of boots on the ground in each of the states and the USDA-backed programs, which makes it really difficult. It makes it really hard to know what you're to do as it relates to growing the product, processing the product, but really more in the sale and marketing and distribution of the products. We look forward to hopefully having clarity as we move forward. But really, as it stands right now, we're looking at a patchwork framework across the United States, with every state being a little bit different.
So with this crazy quilt as it is, like how do you get a direction or make sure that you're not running afoul of what any particular regulation may be?
Right. It's a really, really good question. And I think what we always talk through is understanding any individual operators' risk tolerance regarding this. There are going to be baseline rules, things that you have to follow and you have to abide by before entering into the market. It's probably the easiest to enter into the cultivation or processing side of the market. That is currently regulated on a state level, but it is currently while it's under federal supervision through the USDA, there isn't a lot of oversight from the federal standpoint, and there's not a lot of risk then with respect to growing and processing the products, so long as you're working with a good laboratory that can test the product to certify that it meets the federal definition of hemp at the 0.3% or less THC on a dry weight basis. The science of that is very, very complicated. It has been navigated very, very carefully by many, many companies. And that's what's led to the proliferation of hemp products around the United States in various forms, different mediums, and catering to different markets. As you know, there's going to be the regulated markets that have the licensed retailers that have to have certain rules and provisions concerning them. But there's a lot that are being sold at other locations that aren't through state-sponsored programs. That has led to issues and problems from a consumer perspective.
Especially for kids and young people that are looking to get high on the cheap and they don't even know what they're ingesting. It really is. I'm laughing now, but it's not funny at all. It's super serious.
It really is. And that's where you'll get the intersect then back on the federal level is when you're advertising or selling products that don't meet safety standards, that there are issues then on the consumer perspective. That's where the FDA will and has stepped in when your products are marketing to children, they're marketing for consumption by non-humans, either on the livestock point of view or even pets, and then obviously selling them and advertising them for medicinal purposes. Those are your three categories that the FDA has stepped in. It has issued warning letters and taken action. We've also seen activity and strong positions made by the FTC concerning the sale of these products, asking for information, asking for companies to stop selling the products and advertising the products as they are. And there are ways to ensure that you're walking those lines carefully. But at the end of the day, if you are selling a product across state lines that is hemp-derived, that meets the federal definition, you're doing it by not catering to children, not catering it to for purposes of a medical with a medical benefit and the like. You'll do the best that you can to ensure that you're staying on the right side of this, but with no regulation from the federal level, it can be confusing, and it certainly has some risks baked into it.
Keeping it on the Fed, all the talk right now is about the impending Farm Bill, which is 2 years late, and whether or not they'll get it done by September is a separate conversation. But what I wanted to understand is kind of where, because clearly I'm not a lawyer, where does the sort of the authority of the Department of Agriculture end? As I understand it, it pretty much ends at the plant. Once you've harvested that plant, perhaps maybe first round processing, that's kind of it. And so what can they really do to quote unquote close the cannabis loophole shy of just changing the definition of what a hemp plant is? Is there anything else they can do? Because whatever they do, if I can still create CBD and then turn that CBD into hemp-derived Delta-9, do they have authority to stop that? Then I would be under another agency, either the FDA or perhaps even the DEA, I would assume.
Mm-hmm. Yeah, so you've kind of nailed the head on the nose there with respect to this, because each agency has their respective jurisdiction. And the USDA, it's the United States Department of Agriculture. They're working with the plant product. And we've seen then that same model paralleled on the state level in terms of how they're regulating it. Most states stop where the product is grown, it's harvested, it's tested, and then oftentimes from there it can be sold either to a processing plant or for purposes of consumer sales. And so the issues that we have is not just patchwork between federal and state, but then within the federal government, how are each agency working within each of their authorities with respect to their respective authorities. What I do know that's kind of the focal point of what we're seeing with respect to the new Farm Bill is to close what is a huge kind of uncertainty and openness with respect to the current definition, and that is to tighten up what is in fact hemp and what is going to be a hemp-derived product as a result. And that will, in fact, provide clarity from all of the other angles as well, but it would foreclose huge sectors of this market that are operating correctly, that are operating within normal bounds of typical state programs that are highly regulated, that are tested correctly, product labels provide the requisite information that are there, and then sold under a licensure scheme where the retailers that are selling it are registered with the state, that undergo compliance with the state and have to abide by those rules. So as it stands, to answer your question, is likely it is just going to be limited to the definition as it relates to the current legislative proposals, but then it will have immediate effect in terms of the other aspects of the federal landscape as it stands today.
And when it comes to, the Farm Bill is put together by Congress, not necessarily the people you would choose to come up with this stuff. But my question is, does the Department of Ag, do they have any input into what the Farm Bill is, like, while Congress is coming up with it? Because, I know that I believe it's Representative Miller in Illinois who put in the current language trying to remove intoxicating cannabinoids and redefining hemp. I think it's 0%. Mm-hmm. And, the outcry has been the entire legal hemp industry is built around that definition. And if you take that, you're basically rug pulling everybody, no matter what you're doing with the plant. And so does agriculture, or does the Department of Agriculture have the ability to say, hey, that's a real bad idea? Like, we wouldn't recommend you do that. How does that dynamic work?
It's a great question, and it is correct that if that loophole, for lack of a better description, in terms of it being defined as 0.3% THC on dry weight basis down to 0 of all derived cannabinoids from a hemp product that fall within the THC spectrum, it would pull the rug out from underneath the industry. And Congress does a intense review whenever they are moving forward with amending any legislation. And then here explicitly with the Farm Bill, they will have caucuses and conversations with all relevant stakeholders. Generally speaking, however, these executive agencies, they are going to take a page out of whatever the legislator puts into their book. And sitting here today, I mean, the USDA is not doing a significant amount of oversight concerning these programs because they're set either by the state and then approved by USDA, or they're direct programs with the USDA that are very high level. They are not getting down into the kind of nitty-gritty details of it all, which makes sense because it's an evolving industry and there's a lot of movement that's going on. But as it really stands, the kind of risk factor here in terms of what's going to happen next and so forth is really outside of USDA's jurisdiction because they're focusing in on the production side and then that which will overlap with the processing side, given the fact that it's still a product and it will be on its way to be tested. But it's really, a lot of it remains to be seen. I would be kind of just generally surprised if it has a lot of legs here as we move forward because of the effect on the existing industry. And there are just, quite frankly, better ways to go about regulating it. And we've seen that. We've seen that from the FDA basically saying, long and short is, I don't want to do my job. I want you to tell me how I should be doing my job. And some of that is kind of a precursor to what we've seen in terms of shifts in how much discretion agencies are afforded. Obviously, with some of the Supreme Court developments in this arena has made a significant change on how we anticipate agencies considering these issues. And that's been kind of building, obviously culminating this last session.
One last little side question.
Yeah.
There's no way they're passing this by September.
No.
I just want to make sure. Okay.
I think it's very, very, very unlikely. It's a question we get frequently because it's huge, right? It will have a tremendous impact on everything.
Election year, I mean.
Correct. And this is the same thing from the hemp industry side. And then if you're looking kind of at the high THC kind of core cannabis, for lack of a better description, there's such a patchwork on the states that the effect is, it's not going to be a one size fits all. It just cannot.
Yeah. Well, what are your thoughts around rescheduling or how rescheduling from Schedule 1 to Schedule 3 will impact the legal and regulatory framework for marijuana?
Yeah, that's the $1 million question, right?
Yeah.
I mean, I think there's going to be a lot to be seen still. I mean, I think now, speaking of something being unlikely, I think that's something that is all but certain, right, to occur based off of everything that we have learned and the processes that are in place. But what that will look like is still largely unknown and unclear. I do expect on day one, though, that we will know more as to what that will look like. And it will be largely driven by the DEA and how they decide that they want to go about addressing the fact that this is now no longer a Schedule 1 to a Schedule 3 substance. For example, and kind of the best one that I think is easy for our current operators to understand is typically if you have a controlled substance and you're going to be either testing it or using it for research or otherwise selling it, you have to have a DEA license. And the scope and the parameters of that differ depending on the type of scheduled substance or the substance itself. So I think we're going to seek on day one what DEA is going to require for various, operators within the space concerning this product. It may simply require everyone to be registered so that DEA knows all of the different parties. And so that would be more or less a one-for-one. You're licensed on the state level, you're then licensed with the DEA. They, though, could be more involved. And that certainly will upend, in my view, the current structures that we have in place, which really could get complicated as a result of the fact that we have very complex and very thought through in some instances, but also not thought through in other instances in terms of what we're seeing on the state level, certainly with respect to the states that have been operational for a very long time, that are not just medical, they also have adult use. And as a result, there's still a lot to be seen as it relates to the real practical implications of it. Though, I mean, I think everyone's favorite, right, with respect to that is the 280E will go away. Whether or not that will be something that will be applied retroactively or only prospectively is an open question as well. But those are really kind of two big pieces to that puzzle. But as it stands today, there's really not, as an operator, a lot that you can do other than continue to stay apprised as to what is going on, stay compliant with state law, because long and short is, I think it's most likely that at least right out of the gate, there won't be significant change as it relates to what you're supposed to be doing on the day-to-day basis, so long as you're staying compliant with state law.
So given the greater likelihood of rescheduling, are you advising your clients to continue to operate in the way that the world is today, or are you helping them plan for what might be in the future?
So it's both, actually. Really, as to the day-to-day, there's nothing more that you can do because we just don't know, right? It's to stay compliant on the state level, continue to grow operations. We have new states coming online every day, so to continue to grow your current footprint and do so with the same risk profile that you have been working under thus far. It is not federally legal, right? It is not legal to sell this product, and that's something that all of operators are working with on a day-to-day basis. As it relates to planning for the future, that absolutely has to be happening right now. Largely, though, it's more of just devising what are the potential contingencies and making sure that everything that you have in place is currently compliant and being ready for that next stage should it come. And the more notice that you can have in terms of what it will be, the better. But I don't expect we're going to know more for several weeks or really months at this point.
Going back to the rescheduling, is there any chance that they could say that Schedule 3 applies to, let's say, the isolated cannabinoid? I'm thinking, and in a pharmacological sense, because like we have Epidiolex and CBD, and that's regulated. And let's assume, all right, that's now Schedule 3. And yet we treat CBD kind of out in the wild under the FDA as, well, it's this plant derived or a plant, more as a supplement. Could they do that? And then, basically separating like isolated THC specifically for medical purposes from the state adult use, and we'll rename them wellness, so it's no longer medical, and have them remain separate and allow for what is ultimately legalization? Or does the government not work that way?
So it could be that. There could be about 100 other variations that we would be working with right now. And that's where, I really appreciate the question, what are you advising folks to do right now? And it's really business as usual today. But I think the biggest thing we're going to see is boom in research and development in terms of really getting to the bottom of the medical uses and derivative of not only just kind of the whole plant and whole flower, but all the derivatives therefrom. Because, this is a magical plant. There is so much potential with it that has really not had the right attention in terms of assessing and analyzing all of its potential. We have a lot of great testing that has been done and analysis that's been done, but not in the traditional sense. And I'm sure you're aware, the pathway from taking something from stage 1 to market in terms of the kind of the medical community, it takes years. Mm-hmm. It takes years. And so we're really going to see there's really a huge variation. We're going to see a lot, I think, of change, but I don't see a change happening very quickly. I think it's going to need to be in a kind of more organized fashion, likely industry driven. And ultimately, there's only so much resources available to the federal government and to the state governments. And we've seen that play out really on some of these state industries and how their development and how they're policed, and really just how they're regulated is something I think we're going to see from the federal level. But my dream is that there is some, cannabis czar that gets appointed who then is interacting with each of the different agencies. And the FDA has someone right now that's working like that and trying to interact with different agencies to understand the various roles and who's doing what, in order to be able to be constructive with this, because this could really turn into a huge mess.
So do you envision the marijuana market and the hemp market integrating or interacting in the future? Like what's your long-term vision for that?
So it's a great question. So they already are interacting some, right? You can have, hemp products sold at your dispensaries or sold with marijuana, for lack of a better word. The defined terms are always difficult because cannabis as a plant is both hemp, right, and the high THC derived products or high THC plants. So they're already interacting some. I just don't know if it's really going to be a one-to-one down the road, because hemp has developed in its own industry. It's its own layer on top, or really kind of below, right? It's kind of under the radar in some respects of our current cannabis operations. As sort of a side story that I think kind of parlays to help answer the question, it's actually easier to advise and work with an operator that's in the core cannabis, in the licensed cannabis market, growing high THC plants, selling, having them processed through the state programs and sold at state dispensaries, versus working with companies that are either growing, processing, or selling hemp products, because those are able to be sold across interstate borders and sold in different states. But then you have to be mindful as to each state and how they view each of the products. And so my vision, if this was done in Kristina's world, so to speak, would be probably a meeting in the middle, where you still have regulation, you still have products being monitored, but you're not in the same kind of strict. And there's some states that actually meet this model or are close to this model, but don't have the same kind of strict guidelines as to them, because they have to be, right? Because it has to be within the state and cannot be between one state, and it cannot be cross interstate borders. But I think many the underlay of the hemp industry as it stands today could use a little bit more oversight, right? And we have states where there is oversight, but it's not the same level as we see on the marijuana or core cannabis side. And so I think some sort of meeting in the middle, and that's really on the recreational piece. I think medical will always have to be pretty well regulated, given the intended use of the products and the fact that you will have patients that are critically ill that are relying on it for their wellness.
Well, from my finance background, I imagine it to be a place where someday there'll be a financial exchange where you can hedge forward market and futures markets for the underlying agricultural product. I think then we will have arrived.
I think that's right. I mean, that's another big piece. You would think with rescheduling, it would ease on the available financing for various companies that want to either enter the industry or are in the industry. And I don't know that we're going to necessarily see that right away here. There has to be some de-risking, some certainty before you're going to see what you're talking about.
So I want to talk about, before you had pretty well covered what are the risks if you're an existing operator. And, as a quick recap, it's, hey, stay in your lane, follow all the rules. And I'd say, hire really good counsel to keep your eyes open for you legally. But looking into your crystal ball, if we were to try and advise an investor on the legal landscape of hemp-derived cannabinoids, particularly intoxicating hemp-derived cannabinoids, what kind of outlook would you give to them? Like, we've kind of already determined nothing's happened in this September, so you've got about a year. How long, what's the sort of the time horizon would you guess, based on what you know about how slow the government generally moves, until, should they be investing in new companies today as opposed to just sticking with existing operators?
So it's a great question. And, we've seen a lot of change, since 2018 to today. But if you look back 3 years to today, that to me is the kind of time period that I would look at for the next 3 years, the next 6 years, so on and so forth, in that slow moving. So I don't expect much change from the federal level short of DEA taking action. That's where, in terms of an enforcement arm of the federal government, I see them as what is the most likely next actor on the federal level. And I think your time frame's right. Looking ahead about a year, like they're busy right now working on the rescheduling. What's going to happen thereafter? And there are currently plans in place to consider better regulating from the DEA and an enforcement side, hemp products and hemp-derived products. That said, we're seeing states come online and having sophisticated programs every day, but also we're seeing states come online and basically doing what the legislature or what Congress can't do on the federal level, but doing on the state level. And so it really, as I see it, the 3 years growth we've had in the industry, it's going to be, in my view, just slow and steady over the next 3 years because it's a little bit of a give and take. Mm-hmm. You've got another state saying, no, please, you can sell here, but please follow our rules, right? Follow these labeling rules and so on and so forth. But then you're also going to have states that are going to be pulling back and saying, no, like we've seen in certain states where they redefine hemp on the state level and say you cannot sell these products here in a version of what we're seeing currently in Congress in terms of closing out the ability for hemp-derived products to have these various cannabinoids or the higher level THCs following the testing on the 0.3% dry weight basis. So I think it's going to be slow and steady. I think we'll know more in a year, and I would keep an eye on the DEA.
We've certainly seen a significant drop-off in investor activity. Mm-hmm. It's surely risk-off for them. In fact, today, I think I saw a headline from Green Market Report showed that capital was down, investments down 40%.
Yeah.
So it's rough out there. It's super difficult.
But it is a growing market. We work with a lot of companies that either have been established or are expanding. And that's where you'll see, I think, the most growth or most potential is when you are looking to expand your operations into other states that have established markets that are well regulated. But it really will be, I think, on a patchwork basis, and that's likely where you're seeing some of this change.
Next question. Supreme Court Chevron decision. How could that potentially play once the new farm bill is finally settled upon? Let's say next year, next September, they finally put it together. Can the hemp industry use that ruling to try and challenge the administration or the FDA, the Department of Ag, and have an effect? Because I don't have a complete understanding of this Chevron decision. So you could add some of that in there too.
So the question is whether ultimately we're going to see more challenges, and that's an easy answer. Yes,
for sure.
We've seen an eroding of the deference afforded to federal agencies for several years, really more than that even, but really in the recent years. And this is just, for me, papering ultimately the fact that agencies aren't going to be afforded the same level of deference that they had previously been afforded, requiring you as a regulated industry operator to have to overcome the deference that is afforded to agencies. So here are the kind of three things I would say are takeaways. One is I think we're going to see agencies be more cautious and careful in their decision-making processes. I expect that they are going to really try to understand what it is that they do have authority to do and what they don't have authority to do. Two, I think you're going to see a lot more input on the legislative side. The more explicit and clear the legislative intent is, the more clear and, frankly, stable the eventual regulations and the next steps as it relates to whatever that may be. And in this case, what the USDA will do, what the FDA will do, and what really the DEA will do, and then obviously the FTC is going to be involved as well. And then the last piece is you're going to see a lot more challenges. You have better ability to challenge an agency determination. Agencies' deference now is virtually no longer in existence. And frankly, we've seen this on the state level as well. There's varying levels of this, which I expect we're going to see some, I think at this juncture, open season, right, with respect to this, which, I think is good in some respects and not good in others. And I think there's a way to provide a balance on a move forward basis. So it isn't just like every time a decision is made, agency decides to, establish a new pathway, for example, by the FDA, that will get all of its decisions will be challenged. Because otherwise, how are you to operate? How are you supposed to be a successful industry player? And that's where we hopefully will see better, which is hard to say with our current Congress, but better laws that provide more detail in terms of what is the legislative intent concerning the area, in this case, right, as it relates to hemp and what it is that Congress is intending for the industry to respond and the regulations to go from there. Ultimately, I think we have, this is the last piece I think I'll say on this point is, I do expect, this is my crystal ball on this, if something is being regulated by an agency that is their core area of competence, there still will be some level of deference. Even if it is you're coming to me as the expert in this area, and here's the rule that you promulgated, and here's your decision concerning that rule. You went through all the right notice and comment periods, you've got all the input from the industry, and now you're merely making decisions on that, and it's your core area of competency. I still think that there will be some level of deference, even if that word isn't explicitly used. There will be really no choice for courts because they're sitting here trying to make a decision on items that really are the purview of the respective agencies, and the balance of power within our federal government really depends on some level of deference, even if that's not explicitly the word that's used.
Mm-hmm. Well, let's bounce outside of the U.S. for a minute here. What are some of the legal hurdles that exist for import, export of hemp-derived products? And where will international regulations come into play?
So there are so many hurdles. Like, if you think there's hurdles going from one state to another state, I think it's probably easier to talk about import than it is export, merely because the U.S. has current rules that allow for these products. They're not considered controlled substances, but you have to abide by and be able to demonstrate that you are following all of the rules, not just from the federal level and demonstrating the requisite testing requirements, but the state in which you're importing it to is going to be critical. Export's harder, and I say that because there's really a patchwork, and the way that the United States has developed is very different than other countries in terms of how their structures are in place. We have our friendly neighbors in the north, right? They have a pretty sophisticated program as it stands. But ultimately, I think the best avenue for which to go about the import-export and to consider is whether you're going to sell the actual import or export the actual plant product, or are you import-exporting the finished hemp product? Because those are two sides of the same coin, but very different in terms of potential for seizure and potential for issues concerning their import or export. And as I always say, check the rules in the location in which you're shipping and check the rules in the location in which you're receiving, and ensure that depending on where the product has to go between the two, you're not running into any issues. But it's definitely mirrored right now, and there's been a whole bevy of cases where products get seized and there's a lawsuit because it's a lot of money and it's at times perishable products. And I think that environment's gotten a lot better, but it's still not perfect yet.
When it comes to the safety of the finished products, what are the responsibilities of current operators in the hemp market, not so much the regulated cannabis side, to protect end consumers from those maleffects from their products?
Yeah, that's the most important question you can ask for anyone who's operating in the hemp space.
Thank you.
Bingo, Sparky.
Because what we currently see at both the state level and on the federal level is a reactionary enforcement procedure in place. So virtually every state that we work with, and then even on the federal level with what we've seen from the FDA and the FTC, is, are you marketing something inappropriately, or is there a consumer complaint complaint associated with your product. So if you're not selling a product that is what you say it is, or has other issues associated with it because it's in the hand of a minor, or it's been provided to someone who believes that it should be used for a certain purpose and it's really not intended for that purpose, that's where you run into problems. And so really the best advice is know your partners, know where you're getting your product from, and you know who you're giving your product to. So if you're a processor, ensure all of the cultivators are providing you products that you know are either regulated by that state or are in a state that is regulated, and you have comfort with the product that you're receiving. If you are then selling to a retailer, either because you're a supplier, you're someone who's engaged in white labeling, or you're a distributor, know your retail outlet, ensure that they're following the rules of that given state. In particular, I think the biggest concern that we're seeing across the board is sale to minors. Ultimately, there isn't a restriction on that, right, as it relates to the Farm Bill and how hemp is defined federally. But there are many states that require it to be 21 and older, states that don't permit marketing to minors. And then ultimately making sure when you're having the product tested that it is tested by an independent laboratory and that you're providing information concerning what is in that product on the label of that product. Labeling is a huge piece of the puzzle, but probably the most difficult to manage as an operator because it really happens once, but the rules are changing all the time, and you're selling in a lot of different states which have different rules governing what it is that you're doing. And so long as you're meeting each of those states' labeling rules, you're saying what it is that you're selling is in fact what you're saying it is, you're not providing any medical claims associated with it, and in fact providing some disclaimers concerning any potential medical claims, it puts you in the best position possible to know that when you're selling the product and your consumer is consuming it, they don't think it's going to be used for something else. You're not going to result in any consumer complaints. You will. It's always that way. But that's how the enforcement is currently set up. And so that's the best way, in our view, to de-risk the operations.
One question we love to ask all of our guests on This is Supercritical is, what, in your opinion, is the most supercritical, the most important need-to-know issue facing the adult use, medical use, hemp-derived market in terms of legal and regulatory issues?
So it's
the big question.
It's a big question. It's a question I was expecting, obviously, sitting here today. And in my view, the most supercritical item is to know your jurisdiction. And you need to know it at every single level. You need to know what's happening on the federal level. You need to know what's happening at the state level. And you even need to know what's happening at your local level as well. And if you, while going through and making sure you know each of those pieces, have good relationships with those that are the decision makers at each of those levels, and have the ability to make sure that they understand, they're educated, and they know what they're doing in terms of influencing policy, making the changes in the law. Does it make sense? Is it going to work? Who's supposed to be responsible? To me, that is the most supercritical piece, because then you can operate today, you can influence what is tomorrow, and you can plan for what is to come in the future.
And tell our viewers, how can they find you and how can they find out more about Ice Miller?
Great. Well, please visit our website at icemiller.com. I personally have a LinkedIn page and an Instagram at SoissonD. I look forward to having any follow-up conversations that anyone would like. Please email me or call me. My contact information is on our website, and look forward to having follow-up conversations.
Kristina, thank you very much for joining us today. And this is Supercritical. Your insights are incredibly helpful. Everybody watching, please join us next week when our guest will be Laurel Dineff from Bedford Grow here in Illinois. And we're going to explore how to build a vertically integrated cannabis company. And please check out all of our podcasts at supercritical.agency and take advantage of Supercritical's complimentary 20-minute consulting session with our cannabis experts. I'm Sparky Rose, and I'm cantankerous. Today, I I'm just going to complain about marketing again. We've talked about this in previous podcasts, but I cannot impress upon operators, brands in cannabis, the importance of marketing. And it's not just because I'm a marketer. You are in the consumer packaged goods industry. You're in a regulated part of it, similar to alcohol. No matter what you do, what you say, or what you think is going to change the mechanics of how consumer packaged goods marketing works. It is based on hundreds of years of human psychology. It's how people make purchasing decisions. And if you try to survive in any CPG vertical, not marketing your product, your life will be very, very short-lived. I've just talking recently to a friend who is in the wholesale sales business in cannabis, talking about how they're having trouble making money because they have brands that aren't investing in basic marketing. They think it's just going to sell itself, the field of dreams. If you build it, they will come. That doesn't exist. You may have some initial success, but what you won't have is repeat purchases because you need to communicate with your consumer, and you need to communicate with them directly and consistently in order to build that emotional connection to your product. A brand is a promise for future emotional benefit. And if you don't continually drive that home with your consumer, you're going to lose.